So one big difference between a human rights case and a common law wrongful dismissal case is that in a human rights case, there doesn't have to be an end of the relationship. There can be a continuum of the working relationship and a complaint can be filed. For example, an employee says, well, I don't like the way that Mary was looking at me. I think she was sexually harassing me, and files a complaint based on a poisoned work environment or some other human rights violation. The example I gave would be a poisoned work environment. Now, the relationship may be a continuum. The individual still work and files a complaint. If the employer takes action against the person because of the filing of the complaint or the threat to file a complaint, that's called a reprisal. And a reprisal remedy can be asserted by the individual even if the underlying complaint, in that case of a poisoned work environment, fails. So the individual can argue that I'm still entitled to relief under the reprisal remedy, compensation for injured feelings. There may or may not be a lost income claim. If there may be, for example, the person's demoted because of the action taken, but there doesn't have to be a lost income claim. So in that situation, a reprisal can be a very, very significant remedy available to an individual. Also, if the employer does not take action to investigate the complaint, as I mentioned in another video, that also is an independent remedy that can be asserted for damages whether or not the underlying complaint succeeds. So there's no equivalent in the common law wrongful dismissal world. If an individual is at work and feels maligned, then there's no civil proceeding that can be taken on account of that alone. If it's cumulative, there can be a constructive dismissal, but we'll discuss that later. So there's a whole different ball of wax here between human rights and common law entitlements to wrongful dismissal. It's a different world altogether.